Welcome to Bankruptcy Unlocked, your legal path to relief.
Welcome to the hidden pitfalls of filing bankruptcy on your own. What you might miss. I'm your host, Abigail Vaca. Thank you for joining us today, Andrew.
Thank you for having me.
Let's jump right in. So my first question is, how common is it for people to try and attempt to file a bankruptcy on their own without the assistance of an experienced bankruptcy attorney?
It's actually more common than you might think for people to attempt filing bankruptcy on their own. They'd like to do that without the assistance of an experienced attorney. This is often referred to as filing pro se or filing self-represented. And while it's possible, it can be incredibly challenging. Bankruptcy law is a complex, and even small mistakes in the paperwork or filing process can have serious consequences, ranging from delays in your case to outright dismissal. For example, people filing on their own might not fully understand which debts can be discharged, how to properly value their assets, or how to protect exemptions. These missteps can lead to losing assets unnecessarily or failing to achieve the financial relief they're seeking. Another challenge is navigating the legal system itself. Bankruptcy involves strict deadlines, mandatory court appearances, and interactions with creditors and trustees. Without an attorney to guide them, many people find the process overwhelming and struggle to complete it successfully. That's why working with an experienced bankruptcy attorney is so valuable. Not only do we help our clients avoid costly mistakes, but we also provide peace of mind by handling the complexities for them. Our expertise ensures the process is smoother, quicker, and more effective. And so clients can focus on rebuilding their financial lives. Filing bankruptcy is a big step, and having the right legal support can make all the differences in achieving the outcome you're looking for.
That makes sense. Can you explain a bit more about the complexities that are involved in filing for bankruptcy that DIY filer might overlook?
Absolutely. Filing for bankruptcy might seem straightforward at first glance, but it's a process filled with complexities that many do-it-yourself filers may easily overlook. First, there's the paperwork. Bankruptcy requires detailed financial disclosures, including listing all your assets, debts, income, and expenses. If you miss something, even unintentionally, it could result in delays, dismissal of your case, or even allegations of fraud. Second, understanding exemptions is critical. Each state has its own set of bankruptcy exemptions that determine what property you can protect during this process. Do-it-yourself filers often misinterpret or fail to apply these exemptions correctly, which can lead to losing assets that they've been able to keep if they filed it correctly. Another common pitfall includes the means test, which determines the eligibility for Chapter 7 bankruptcy. The calculations can be complicated, and errors might cause you to fail the test or be forced into Chapter 13 repayment plan unnecessarily. Timing is also a major factor. For example, if you've recently transferred property, made large payments to creditors, or taken on new debt, those actions could impact your case. Do-it-yourself filers might not fully understand the legal implications of these actions and how they can affect the outcome. Finally, there's the legal system itself. Bankruptcy involves court procedures, interactions with creditors, and working with a trustee. A do-it-yourself filer might struggle with these interactions, which could lead to misunderstandings or missed opportunities to defend their interests. That's why having an experienced bankruptcy attorney is so important. We don't just fill out forms. We provide strategic advice. We protect your rights and make sure the process runs smoothly. Bankruptcy is a powerful tool for a fresh start, but it needs to be handled correctly to achieve the best outcome.
Okay, so you touched on it a bit, but what are some of the potential consequences of making mistakes in the bankruptcy filing process? Are they reversible?
Making mistakes in the bankruptcy filing process can have serious consequences, and unfortunately, not all of them are reversible. One of the most common consequences is the dismissal of your case. This can happen if deadlines are missed, forms are incomplete, or critical financial information is omitted. If your case is dismissed, you may have to start the process all over again, which can be time-consuming and costly. And in some cases, you may face restrictions or delays before you're allowed to refile. Another potential consequence is losing assets unnecessarily. If you fail to properly claim exemptions or misvalue your property, you might end up forfeiting possessions that you could have legally protected with the right guidance. Errors in the filing process can also lead to certain debts to not be discharged. For example, if you don't correctly list all of your creditors or debts, you may still be responsible for paying those debts even after bankruptcy is complete. In more severe cases, mistakes could lead to allegations of fraud or bad faith. This could result in penalties, denial of a discharge, or even legal action against you. As for reversibility, it really depends on the type of mistake. Some minor errors can be corrected through amendments, but others, like a dismissed case or a lost asset, can be much harder to fix. That's why getting it right the first time is so important. Working with an experienced bankruptcy attorney helps you avoid these pitfalls. We ensure everything is done correctly, on time, and in compliance with the law, giving you the best chance at a successful outcome and a fresh financial start.
That makes sense. So, building on that, how does hiring an attorney help ensure that clients choose the right type of bankruptcy based on their unique financial situation?
Choosing the right type of bankruptcy, whether it's Chapter 7 or Chapter 13, is a critical decision that can significantly impact a client's financial future. This is where hiring an experienced bankruptcy attorney makes all the difference. An attorney starts by conducting a thorough evaluation of the client's financial situation. We look at their income, expenses, assets, debts, and long-term goals. This detailed analysis is essential because each type of bankruptcy serves a different purpose and has a specific eligibility requirements. For example, Chapter 7 is typically suited for individuals with low income and little to no disposable income after expenses. It's a quicker process that allows clients to discharge most unsecured debts, like credit card balances or medical debts. However, not everyone qualifies for Chapter 7 due to the means test, which we help navigate to ensure eligibility. On the other hand, Chapter 13 is often the better option for individuals who study with steady income, who want to catch up on secured debts, like a mortgage or a car loan, while protecting certain assets. It involves creating a repayment plan, and this process can be complex. We help clients structure a plan that's feasible and meets the legal requirements. Without professional guidance, it's easy to misinterpret eligibility requirement or overlook critical factors that influence which type of bankruptcy is most beneficial. Filing under the wrong chapter can lead to unfavorable outcomes like losing assets or being stuck in a repayment plan that's unmanageable. As attorneys, our job is to help clients make informed decisions, ensuring they choose the right path based on their unique financial circumstances. By doing so, we maximize the benefits of bankruptcy while minimizing risks, setting up our clients for a stronger financial future.
I think a lot of people operate out of fear for what it's going to cost to hire an attorney. I'm curious, what are some common misconceptions about the cost of hiring an attorney for bankruptcy? And how does that compare to the potential costs of filing without legal help?
One of the most common misconceptions about hiring an attorney for bankruptcy is that it's prohibitively expensive. Many people think that they can't afford an attorney, especially when they're already struggling financially. But the reality is, hiring a bankruptcy attorney is often a cost-effective investment when you consider the risks and potential costs of filing without professional help. Let's break it down. For bankruptcy, filing for bankruptcy involves court fees and other expenses, whether you work with an attorney or not. But if you choose to file on your own and make mistakes, like missing a deadline or misfiling forms or failing to protect your asset, it could cost you significantly more in the long run. For example, you could lose property you might have been able to exempt, or you could end up with debts that aren't discharged due to errors in the process. On top of that, if your case is dismissed because of mistakes, you may have to refile, which means paying court fees again. These kinds of setbacks can financially and emotionally be draining to you. Hiring an attorney helps you avoid these costly errors. While there is a fee for legal representation, most bankruptcy attorneys offer payment plans or offer flexible options that make their services admissible or accessible. And when you think about what you gain, peace of mind, a smoother process, protection of your assets, and the assurance that debts will be handled properly, that value far outweighs the costs. Bankruptcy is a big step, and having a knowledgeable advocate by your side ensures you're maximizing the benefits of the process while minimizing the risks. It's truly an investment in your financial future.
So how do attorneys handle the legal complexities of dealing with creditors? And why is this an area where DIY filers get into trouble sometimes?
Dealing with creditors is one of the most challenging and legally complex aspects of filing for bankruptcy. And it's an area where having an experienced attorney on your side makes a world of difference. When you file for bankruptcy, the automatic stay goes into effect, which legally stops creditors from contacting you, garnishing your wages, foreclosing on your home, or taking other collection actions. This is a powerful protection. Enforcing the stay and dealing with aggressive creditors can be tricky, especially for do-it-yourself filers. Creditors have their own legal teams, and they may try to challenge the automatic stay, dispute the discharge of certain debts, or pressure you into agreements that aren't in your best interests. An attorney knows how to handle these situations effectively. We communicate with creditors on your behalf, ensuring they comply with the law and protecting you from harassment or unfair credit practices. Additionally, attorneys are skilled at addressing creditor objections, which are common in the bankruptcy cases. For example, a creditor might claim that a particular debt shouldn't be discharged, such as debts incurred through fraud or recent credit card purchases. We know how to build a strong legal argument to counter these claims and protect your rights. Do-it-yourself filers often get into trouble here because they may not fully understand their rights or how to respond to creditor actions. They might accidentally waive protections or agree to unfavorable terms, which can determine or undermine the benefits of filing a bankruptcy in the first place. By hiring an attorney, you assure that someone with experience and expertise in advocating for you in every step of the way. We take on legal complexities so you can focus on moving forward with a fresh financial start.
So if someone decides to file on their own and then later faces complications, is it possible to bring in an attorney midway through the process? How does that work?
Yes, it is possible to bring an attorney midway through the bankruptcy process if you run into complication, then it's often a very smart move. While it's always ideal to have an attorney involved from the beginning to avoid these problems, we understand that some people try to file on their own and later realize they need help. When a client comes to us after starting the process on their own, the first thing we do is review their case thoroughly. We look at the paperwork they filed, we evaluate any deadlines or hearings that are coming up, and identify any issues that need to be addressed immediately. Depending on the situation, we may need to correct errors in the initial filing, amend schedules to include missing information, or address objections or challenges from creditors or the court. If the case has been dismissed, we can often help clients refile and guide them through the process to ensure it's done correctly the second time. It's important to note, though, that the further along you are in the bankruptcy process, the more complex it can be to fix mistakes. That's why reaching out to an attorney as soon as complications arise is crucial. The sooner we step in, the better the chances of resolving the issues and achieving a successful outcome. At the end of the day, bankruptcy is a powerful tool for getting a fresh financial start, but it's also a legal process with many moving parts. Having an experienced attorney by your side, even if it's partway through, can make all the difference in protecting your rights and ensuring the process works for you.
All right. Well, you left us a lot to think about. Thank you so much again for joining us today, Andrew.
So thank you. It's been my pleasure.
And thank you for joining us for the hidden pitfalls of filing bankruptcy on your own, what you might miss.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.